Let's see. All right, you're Michael White. And this is cause number 24, DCCR 0782. And Mr. White was previously found not competent to stand trial, sent to the Dunn Behavioral Science Center. And we received a report from them dated April 4th of 2025. That report is from Samantha Guzman, and the opinion in that is that he is still not competent to stand trial, with the finding that outpatient competency restoration could potentially be something that would work for Mr. White. The problem with that is that we don't have an outpatient competency restoration program, and so and that he's not likely to achieve competency. So I don't know exactly where that leaves us. Mr. Smith, what's the...
Judge, I believe his mother lives in Florida. She's willing to take custody of him, and I believe they have a program that is along the lines of this with outpatient competency restoration.
Yeah. Would we do that through a civil, or would it be a dismissal?
That was the question I had on you. We're willing to do whatever it takes to get him there.
And Judge, if I may, I've been talking with his mother. She's been in contact with the probation department there, just trying to get familiar with what kind of programs they have. They have a program there called the Gateway Program that works with their mental health department. That's basically similar, goes along parallels to what this would be. And the only issue that they've been having to try to get information on Mike is, from my understanding, they can't do the interstate contact without it having an out date or anything from when they would be getting out to leave to go down there.
But I can't, is this a motion or is this a new case?
It's a motion, because he was sent back from ISF, Judge.
Yep.
Okay.
He was sentenced to ISF as a term and condition of the probation term.
Mm-hmm.
He got to ISF and then started to regress.
Right.
So I can, without pleas of true or not true, really, I think on that motion, I think we can just order that he live in a certain place, which would be with her, that he participate in those programs, and then the probation could transfer to that, correct? I mean, we can't do obviously any kind of pleas on anything.
No,
so
I
it would
agree.
require a dismissal of the motion to revoke.
I don't know, do we actually have a motion filed? I believe we just had this set for hearing because he was returned from ISF.
Gotcha. Okay. So then we just need probation to do the, I don't know if you would necessarily take an administrative hearing or just send in me the order to sign, ordering the Gateway Program through, and if you can get the county and the address of it, where his mom lives, and
I
get
got
all
her
of that.
address and that information this morning, so I
You can get all that to probation. Does that sound like something we can do? Okay. Well, let's do that then. We'll just not go forward with anything, motions here. Let's just, whatever conditions you need to add with regard to him being able to go there. And then we can kind of figure out when that's going to happen so that they can get transportation. So if you'll work with probation, y'all get all that worked out.
Okay,
Okay?
no problem.
All right.
Thank you.
We're going to get it where you can go live with your mom in Florida, okay? But you still have to follow the rules. Y'all marked second degree.
We're going to proceed on at least one of the priors, Judge, with the court's permission. It is not something, there are additional priors that would enhance him that are not required under law, if that makes sense. Jurisdictionally, they're not required, but.
Let's see. So it looks like there's two. The first two are, well, we've got to,
So he received 5 years TDC on the 93 case and then 90 days on the 98 case. And then my position is that at least that 2004 or the 2009, whichever the court would like to recite, would enhance him from the third to the second.
so he'll plea on all, let's say, except for that last one, because that would actually enhance it again.
Yes.
All right. So you'll waive the March 3rd, 2009. We won't go on that, but everything else. Does that make sense to you too, Mr.
Yes, ma'am.
Parker? All right, sir, are you Alfredo Gayton?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
He will, Your Honor. I gave you
Okay.
I think so.
Yeah,
I think I
did,
already
did,
signed
I
it
did,
and
okay.
handed it over. Give me just a second to get this pulled up. Mr. Gayton, in cause number 25 DCCR 0184, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's from March 30th of 2024. The indictment alleges you were previously convicted of driving while intoxicated September 28th of 1993 in Harris County, Texas, and then after that, and then on July 9th of 1998, convicted of driving while intoxicated in San Patricio County, Texas. And then after that, you were convicted on July 28th of 2004, again in Harris County, of driving while intoxicated. And how do you plead to that charge?
Guilty, Your Honor.
And are those prior convictions true?
Yes,
Did you enter your plea of guilty and true freely and voluntarily?
yes, ma'am.
And because you actually did what they've charged you
Yes,
with?
ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a cap of 14 years in the institutional division of the Texas Department of Corrections. I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. You could have that jury decide if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that right, and you're leaving your punishment up to me. And as long as I don't give you more than 14 years, then you're waiving any right to appeal. Do you understand? Also, do you understand, if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Gayton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information.
This is a critical turning point in the hearing. Competency issues are now front and center. When a defendant is still not competent to stand trial, the entire case shifts from punishment to treatment. The big question here is, can justice even proceed if the person doesn't fully understand?
Information to Mr. Parker, and he'll present it to me on your behalf when we come back. All right? You can go back with the bailiff. Thank you. Good morning. Are you Sean Harley?
Yes, Your Honor.
And Mr. Parker, will your client waive a formal reading of the indictment in each case?
You will, Your Honor.
Mr. Harley, in cause number 24-2148, you're charged with the state jail felony offense of criminal mischief, and that's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then in cause number 25 DCCR 0739, you're charged with a third-degree felony offense of harassment of a public servant. That's from August 28th of 2024. And how do you plead to that charge?
Guilty, Your Honor.
Again, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And because you did what they've charged you with?
Yes, Your Honor.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
Objection?
It's admitted. Is there any evidence that Mr. Harley is not competent?
No, Your Honor.
All right, Mr. Harley, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily.
Yes, Your Honor.
Find that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 24, DCCR 2148, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with your agreement to a term of 1 year in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 0739, also find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I've handed you the trial court certification in each case that shows these were agreements and that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
Yes,
All right, good luck to you, sir. You can go back with the bailiff.
And just like that, multiple defendants walk away with structured deals, but the real takeaway is consistency in sentencing. Guilty pleas, waived rights, and concurrent sentences all show how plea agreements drive today's courtroom outcomes. But the question remains, is this efficiency or leniency?